Hello, my name is Amber Dahlgreen Curtis. I'm an attorney at the Westminster law firm of Delaney, Leahy, Curtis, and Brophy. I practice in the area of estates and trusts. I write wills and trusts, and I handle estates when people pass. I've been doing this for about 3 decades, and I really enjoy my work. Today, I'm going to talk about the documents that should be part of everyone's estate plan. And there are 3 documents that are absolutely essential. The first is a Maryland Medical Advance Directive. This document allows you to say in advance of any kind of medical disability who should be able to make medical decisions for you. The second document is a financial power of attorney. If you become disabled, then you're naming somebody to be able to handle your finances for you. And then lastly, the document that more people know about is a will. That's the document that says what happens when you pass and where your property goes. I'll start with advance directives, medical advance directive. When you write a medical advance directive, one of the first decisions you have to make is who you should name as your medical agent. This is the person who will make medical decisions for you if you're unconscious or incompetent and you can't talk to your doctors for yourself. And so you should think hard about who that person should be. The kinds of skills that you would want them to have are the kinds of skills that work well in a hospital or clinical setting. Is the person you're thinking about naming proactive? Will they talk to your doctors? Will they be available? Will they make sure that you're getting the best care you possibly could? If they're not happy with how your doctors are handling things, will they ask questions? Will they make changes? So think about the people who are available to you, and do you think they would do a good job with this kind of work? Once you've named the agent, then you need to give them some help. What are your wishes with regard to your medical care? Your family members or your agent won't know unless you've told them. The second part of a medical advance directive is sometimes called a living will or healthcare instructions. It's the part of the document where you say whether you would want particular treatments or not want them. In Maryland, there's a suggested form for a medical advance directive, but you can use any form that you'd like to. Some religious organizations have forms that they suggest. The Maryland Attorney General's Office has a suggested form. The most important thing is that you take the time to get a form, read through it, make your decisions, and make sure that it's signed appropriately. But let's go back to those healthcare decisions. In general, a well-written medical advance directive will say what you want in at least 3 particular situations. So the first is generally a terminal condition. A terminal condition is something like a cancer diagnosis. It's a diagnosis that's most likely to end in your death. Would you want to be kept alive on life support or life-sustaining substances in that situation? Oftentimes people would say no. And if that's your wish, then it's very helpful to your family and your medical providers that you would say that so that they know in advance what your treatment preferences are. The next medical situation that's covered in a Maryland Medical Advance Directive is persistent vegetative state. That means you're not conscious, you're not aware of your environment, you're not able to interact with others. What would be your medical wishes if that were the situation and there was no reasonable expectation of your recovery? Again, it can be very helpful to your family members to know what your wishes are. Even if you've told them, it's still helpful for these things to be in writing. It's difficult when you have to make that decision for a family member, and if you've put it in writing for them, it will give them a good deal of comfort that they've followed what you've asked them to do. In some ways, you're taking the burden off their shoulders, and you've made the decision. They're just putting into effect the decision that you've already made. And then finally, there is a medical condition called end-stage condition. That's a condition caused by injury, disease, or illness. You've suffered severe and permanent deterioration. indicated by incompetency and complete physical dependency, and for which to a reasonable degree of medical certainty, treatment of the irreversible condition is medically ineffective. What would be your wishes in that case? Would you want to be kept alive on life support or life-sustaining substances? Would you want to have doctors intervene? Would you want no treatment? Again, help your agent by being able to give them your thoughts on these situations. Once you've thought about the living will, you might have certain circumstances that are special to your own healthcare condition. If you have anything in particular that you want your agent to know, there are places on forms where you can write specific things. My general philosophy is that you want to talk to your agent in great detail, and the medical document in writing, you may just be more general. There will often be sorts of situations that come up that you couldn't even predict. And so the most important thing is that you choose somebody with whom you have complete confidence. You let them ask all the questions that they need to of your medical providers, and then you're comfortable with the decision that they'll make on your behalf. There's another document that often gets confused with a medical advance directive. That's called a MOST form, and the M and the O in that acronym stand for medical order. A medical order is different than a medical advance directive. The MOST form is actually prepared by a physician and is a medical order in your charts. You don't have to sign a MOST if you don't want to. In some circumstances, you may want to sign one for a particular surgery or a particular condition, and then you may want to revoke it at a later time. The last part of a medical advance directive is usually a HIPAA waiver. HIPAA are the federal privacy laws that relate to medical treatment. Healthcare providers, your doctors, they're very conscious about not releasing your medical information. And while that sounds good, it can be problematic when your family needs to know what your medical condition is so that they can make wise decisions for you. So the third part of the medical advance directive is a HIPAA waiver, where you waive the federal privacy laws for the benefit of your family member or your agent, and that allows them to talk to your doctors, your healthcare providers, doctors in a hospital. They should never be told that they can't hear what your condition is. After all, they're the very people who need to make decisions for you. Sometimes when you go to your doctor's offices, you'll be presented with their healthcare policies. Feel free to sign all of those documents and name the same people that you've named in your medical advance directive, so that the office in particular that you have your physician in can know without certainty on their own forms that they can talk to those family members. It's fine to be repetitive in this area. We are so much more concerned that a healthcare provider won't talk to your family member than that they will breach your privacy. Next, I'd like to talk about financial powers of attorney. We've talked about medical documents. Now we're moving on to a different topic. If you have a period during your lifetime where you are incompetent, and it's not fun to talk about these examples, but just to help you picture it, think of someone having a stroke, or think of someone who has Alzheimer's disease. These people are not able any longer to handle their financial matters. And so, we're hopeful that in advance of that situation, the person will have named a financial agent to handle their finances for them. It's called a power of attorney. Now, once I took a phone call in my office from someone who called, and she said, "Mrs. Curtis, are you an attorney?" And I said yes, and she said, "Good, because I need the power of an attorney." And I laughed, not out loud. I laughed to myself. I think I had to bite my tongue so I didn't laugh into the phone. But attorney in this case just means agent. It's an old English word. And so oftentimes someone might think it has to do with a lawyer, but it doesn't. The attorney, in this case the agent, can be your own family member. It's the person you're naming to take care of things financially for you if you can't do it. Maryland in 2010 developed a statutory form power of attorney. Statutory just means there's a law in which these very words in a suggested form are written. It's a good idea in Maryland to utilize the statutory form. It's widely regarded, it's easily accepted. When it's presented by your agent, whoever they've presented it to will not be surprised at what they're reading. You don't have to follow it as a suggested form, but I think it's wise to. The form talks first about who you've named. Who will you make as the person in charge to handle finances for you? Think about the kinds of things they would have to manage for you. Do you own real estate? Where do you do your banking? Do you have stocks and bonds? Someone will have to file your tax returns. They have to have authority to sign them for you. What about claims or litigation? What about insurance? Maybe you have long-term care insurance. Someone would be able to make that claim on your behalf so that the funds that you have paid for in your insurance policy can start to come in to cover your care. No matter what the assets are, everyone has some assets, even if it's only monthly income from a pension or from Social Security. Those assets need to be managed by somebody who is responsible. So think carefully about who you'll name. Are they a good record keeper? Will they be conscientious about filing tax returns? Will they keep in touch with you so that you can help them along to the extent you're able? Sometimes you have a situation where a person is completely competent, and it's easy to know that. Sometimes a person's completely incompetent, and it's easy to know that. In between can be more difficult. Sometimes a person may understand some things but not exercise the kind of sound judgment that they used to. Sometimes they might be able to make a decision with a little bit of help. And so, in that situation, I think it's wise that you have someone who will walk alongside you, and you can do as much as you can, and they'll help with the rest. So that brings up a point that's often discussed in powers of attorney. When does the power of attorney become effective? The legal answer is that it becomes effective when you say it does. There can be a triggering event, your disability, that brings the power of attorney into effect. My thinking on this, which I'm happy to share, other people may think differently, but my thinking is that you would not give a power of attorney to someone that you didn't have complete confidence in. But once you know who that is, I think it's wise to allow them to make decisions from the time the document is signed. That way they can help you if that's all you need is a little bit of help. If you write the document so that it doesn't become effective until you're completely disabled, then a doctor or medical professional will have to say when you've reached that point. Oftentimes physicians don't like to come to that conclusion, and it can be difficult for a family member to step in and offer some help, but they would have no authority to act on your behalf until the power of attorney is triggered. So give some thought to who you would name and under what circumstances you would want the document to be used. The agent would physically need the document, so if you've signed a power of attorney, it's important that they know where to find it, so when they need to use it, it can be located. I take many calls a year in my office from family members who don't know if their parent or aunt or uncle has signed any of these documents. They're still looking for them in their houses. If you sign documents, please let someone know that you've done it and where they can find those documents if there's a crisis. Now, power of attorney can be for any number of things that you need done for you. It could be something very small, like who paid your gas and electric bill this month. but it could be a very major financial decision. Say, for example, that your health has deteriorated to the point that you can no longer stay in your home. Who would you trust to make a decision that it's time to sell your residence and would be a person who could manage that task? Could they hire a realtor? Could they go to your settlement? Could they ensure that the sale goes smoothly and to your benefit? Again, complete confidence in the agent that you've trusted, and then think about when that document should become effective. Finally, I'd like to talk about wills. A will is the document everyone thinks about. What happens to my property at the time of my death? The will does say where property goes, but at the outset, I want to share with you what I think is the number one mistake in estate planning, and that's clients not understanding what property is governed by a will. I'll give you some vocabulary words. There's what's called probate property. That's property that passes under your will. And non-probate property. Non-probate property passes to a beneficiary or a joint owner. Let me give you some examples. Suppose you have a bank account that's joint with your child. When you die, the child becomes the owner of that bank account automatically because they're already on the title to the bank account. They don't inherit that property under your will. Your will has nothing to do with that joint bank account. You've passed, there were 2 names on it. You've died, now they're the remaining owner. That can work well if your intention at your passing was for that child to have that account. There can be problems with that arrangement too. Suppose you have more than one child. You put a name on a bank account because you wanted that child to be able to write checks for you. But at death, it was your intention that the money in the account would be split by all of your children. Legally, the money belongs to the surviving joint owner. Now, your family member may share that money, they may not. As an estate planning lawyer, my job is to make sure what you wanted to happen actually happens at your death. I would prefer that you name someone on your bank account as power of attorney. That designation shows that the money is still yours, but someone else has the ability to transact on it for your benefit. It's different than a joint owner. A joint owner says it's their money and your money together. Bad news comes to law offices pretty quickly. And so here are some of the bad news calls I've taken over the years about joint accounts. Client calls and says that their child has filed for bankruptcy. The bankruptcy counsel wants to know all the assets their child has, and the account with the parents' money has turned up as an asset. Or a child is getting divorced. Same thing, child has to provide a list of all of their assets, and now someone else's money is potentially involved in a divorce. Or child gets in a bad car accident and has creditors that were unexpected. Again, somebody else looking for money and finding an account that the child looks like they're an owner of, but it's not really their money. So think about how you've titled assets. Also think hard about who you should name as a beneficiary on assets. If you've named a beneficiary on an account with your brokerage company, with the bank, there can be something called payable on death or transfer on death. You'll hear them called POD, payable on death, TOD, transfer on death. These instructions made between you and the bank or brokerage company or insurance company that holds the asset. These are instructions that have to be followed by those companies. So at your death, they will simply pull their forms, read them, and do what you've said to do. Your will won't have anything to do with it. That means that you need to be very careful with your beneficiary designations. Are they up to date? I've seen many beneficiary designations that name people who've already died. I've seen them that still name ex-spouses. I've seen them that are just not what the person wants anymore. I've had people to write their own wills and change things in a will and think that that's changed something with the beneficiary designation. For example, I once reviewed a homemade will that said, I give and bequeath my IRA to a certain person. The client didn't realize, though, that they hadn't changed what was on file with the company that held that IRA. And so even though they'd written something in their will, they hadn't accomplished what they intended to accomplish with the company. When they died, the money was going to whoever was on that beneficiary designation. It didn't matter what their will said. That is, I think, the number one mistake in estate planning is not understanding what property is governed by a will and not paying enough attention to the titling of assets and to the beneficiary designations that are there. Now, when you go to write a will, your attorney will ask you a variety of different questions. I generally start by asking about your tangible personal property. That's like your furniture, your furnishings, could be an automobile. What are your wishes with regard to these items? Oftentimes, there's not a great deal of value in these items, but it takes a lot of time to sort out what to do with them. Lots of times you may decide that you could name one person to take care of these things, and if you leave your tangible personal property to someone who will make sure that a charity gets the things that you would like them to have, maybe gives some more distant relatives a chance to get your photographs if that's important to them, or will share your genealogy. Pick somebody for tangible personal property who will take good care of the items that have meant a lot to you. I don't think it's very helpful to make long lists in a will of you want this piece of furniture to go to this person and this piece of jewelry to go to another. You can do a little bit of that, but each item that you name specifically in a will has to be inventoried, appraised, and the person who is handling your estate, the executor, has to make a record that they have actually distributed those items to those people. You might be able to make a list and give that to the executor that has detailed instructions about tangible personal property so that you don't have to clutter up a will with lots of very specific instructions. Once you've handled tangible personal property, think about specific bequests. A specific bequest is a particular item or a particular dollar amount to someone you want to have it. Maybe you want to leave $5,000 to each of your grandchildren who are living at your death. Maybe you want to leave a specific amount to a charity. There are many ways to think about giving. There are many avenues to accomplish it. You might use a beneficiary designation. You might make a bequest in your will. An estate planning professional can help you understand what's the smartest way you can make a gift. I'll give you an example. An IRA is a common asset for a client to own. You might have a traditional IRA. That means that no taxes have been paid on the money that's in the IRA. And in this case, when I say taxes, I mean income taxes. When you contribute money to an IRA, you get an income tax deduction for the money that goes into the IRA. When it comes out, that's when it gets reported on your taxes. And that's true of a beneficiary. If they're named as the beneficiary on your IRA, when they pull the money out of your account, that income has to hit the tax return of the beneficiary. And so, here's an example. Suppose you wanted a charity to receive your IRA. If you write the name of the charity as the beneficiary on the IRA, they can collect it immediately at your death, and because they're a charity, there'll be no income taxes owed. So suppose you had an IRA that was $25,000. You could write, and you wanted a charity to receive $25,000. You could write in your will, I give $20,000 to the charity, or you could name the charity as the beneficiary of your IRA. Which would be smarter? It would be much smarter to name the charity as the beneficiary of your IRA. They would get every dollar in the IRA, all $25,000 of it, and they would pay no income taxes. You'd still have the $25,000 in your estate that you could leave to a person. If instead you left the $25,000 IRA to a person, they'd pull the money out but have to pay income taxes. There's a lot to think about when you decide how you're going to make the gifts that you want to make. And an estate planning professional can be helpful to help you think about things you never thought you'd have to think about. So that's specific bequests, a specific item or a specific amount to a particular person or a charity. Finally, you'll think about what we call the rest, residue, and remainder of the estate. When you write a will, you don't just write, I give this property to this person, this amount of money to that person. At the end, you have to have a general paragraph that says, whatever else you own, this is how you leave it. That's so that you're sure that all the property that you own at the time of your death is given away under the will. It's called the rest, residue, and remainder of the estate. In most cases, it's the largest part of the estate. If you're naming more than one person as the beneficiary, one wise way to decide how the assets are received is to come to percentages. We don't know when we write our will what the assets will necessarily be when we die. You might have a great stock market and your assets might rise. You might have significant medical expenses and your assets might be less than when you write the will. So by using percentages, if you have multiple beneficiaries, you're preserving the relationship between the gifts. Do you want them to be equal? Do you want one person to have more money or assets than another? And so when you write percentages, whether your assets have grown or whether they have gotten lower, you will be preserving the relationship of how you wanted your beneficiaries to take the assets. Now you have to name the person in charge of your estate. That's called the executor. That's an old Latin term. The more up-to-date modern term is called personal representative, but they mean the same thing. Your personal representative, your executor, is the person who settles your estate at the time of your death. They'll be responsible to gather and collect all the assets, to provide a value for them by using appraisers to tell them what the values of those things are. Then they make distributions in accordance with the terms of your will. I want to talk for a minute about taxes in Maryland in particular. Oftentimes, because people are more concerned about taxes than they really should be or have to be in estates. Maryland has an inheritance tax. The inheritance tax is based on the relationship between the person who dies and the person who's inheriting. There is no inheritance tax in Maryland to anyone in your lineal line of descent. Parents, children, grandchildren, or further down the line. No inheritance tax. Brothers and sisters are also exempt from Maryland inheritance tax. Charities are exempt from Maryland inheritance tax. It's most often paid by nieces and nephews who are not exempt. There's a 10% Maryland inheritance tax. And friends, godchildren, anybody else that's just unrelated to you, they do still pay a 10% Maryland inheritance tax. Maryland also has, separate from inheritance tax, an estate tax, but we have a very generous limit, or exemption, I should say, a very generous exemption from Maryland estate tax. Unless the assets are over $5 million, there's no estate tax. That's the current law. It could change, but it's been that way for quite a while now. So if you're leaving assets to children and your estate is under $5 million in Maryland, the good news is there are no taxes, either inheritance taxes or estate taxes. Lots of times people think that they have to do very complicated planning to avoid taxes, and they don't have any tax concerns. Now, we said a little bit about income taxes when we talked about IRAs. And income tax can't be avoided. If no one's ever paid income taxes on the money, for example, you put that money in an IRA and now you've passed, so you didn't take it out, but the beneficiary is, the tax that's due there is income tax. It's due not because of your death, it's due because there was never any income tax paid on those assets in the first place. Some assets like annuities may have income tax consequences to your beneficiaries. But in general, just because they've inherited them from you, if they're not someone who has to pay inheritance tax because of their relationship to you, and the amount of all assets is under $5 million, there's no tax. I think I'm ready to wrap up my remarks, and in conclusion, I'll say this. It is extraordinary that we live in a society that allows you to say what happens to your assets at the time of your death. People who are still alive will enforce your wishes over the people who are left. That's really extraordinary if you think about it. It's not just whoever gets there first takes the jewelry and runs. Instead, we have a wonderful system that allows each individual to decide who gets their property when they pass. So, will you take the time to make your wishes known? Will you make things smooth for your family members, or will they be difficult? I take calls every year from families in crisis. There are unexpected deaths. They can't find the documents. They don't know what the assets are. Will you take the time to make things easy and light for your family members? I hope you will. Thank you.